Ever hired someone for a job you really shouldn't have? Like ignored obvious red flags because you needed someone fast?
Oh, yeah. My roommate once hired a babysitter who showed up in a party dress at 3 p.m. smelling like confidence.
Well, that feeling of, I really should have checked this person out better, sits at the heart of today's Supreme Court case, Montgomery versus Caribe Transport. The Supreme Court hears oral arguments in this case on Wednesday, March 4th.
Picture this scenario. A trucking broker hires a driver they absolutely know they shouldn't. The driver crashes into someone, the victim gets severely injured. Can they sue the broker who made the terrible hiring decision?
You'd think the answer would be obvious, but the trucking industry argues federal law blocks those lawsuits entirely.
Wait, seriously? The company that negligently brought on the unsafe driver gets complete protection?
That's exactly what the Seventh Circuit ruled, and it creates a massive split between federal courts about when victims can actually hold trucking companies accountable for their choices. This affects every single person who drives on American highways, because these aren't just any trucks. These are massive commercial vehicles sharing the road with your family.
Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you listen. And follow on LinkedIn to get written rundowns. Just search the High Court Report. Think of it as insurance against getting completely lost the next time someone mentions federal preemption at a dinner party.
All right, here's what you need to know. The formal legal question, and yes, I'm going to make this sound more interesting than it looks on paper.
Please do.
Whether the Federal Aviation Administration Authorization Act preempts state common law tort claims against brokers for negligently selecting motor carriers or drivers whose vehicles subsequently cause accidents.
Wait, why does the Federal Aviation Administration have anything to do with trucks?
Great question. Congress basically copy-pasted the airline deregulation language when they deregulated trucking. So we get this weirdly named law governing trucks.
Breaking that down further, this actually involves two separate legal questions smooshed together.
First question, does federal trucking law even apply to negligent hiring lawsuits? Second question, if it does apply, does the safety exception save these lawsuits anyway?
Think of it like this. Congress told states, you cannot regulate trucking economics anymore. We're handling that federally. But they added, except for safety stuff, you still control that. So the fight becomes, does suing a broker for hiring a dangerous driver count as economic regulation that federal law blocks? Or safety regulation that states still control?
The facts here will make you never want to park on a highway shoulder again.
That sounds ominous.
December 7th, 2017, just after midnight, Sean Montgomery drives his tractor trailer across Illinois on Interstate 70. His truck breaks down, so he pulls over and parks lawfully on the right shoulder.
Pretty standard breakdown situation.
Meanwhile, Yosniel Varela Mojena drives westbound in another tractor trailer, but he's fatigued and distracted. He drifts out of his lane onto the right shoulder and slams into Montgomery's parked truck at full highway speed.
Oh no.
The impact detaches Varela Mojena's trailer completely. It swings across the highway and lands on the median, and then Varela Mojena drives away from the scene without stopping.
He just left?
Left his detached trailer behind and fled. Montgomery suffered severe injuries requiring multiple surgeries, including amputation of his leg below the knee.
That's horrific. But where does the broker fit into this?
Here's where it gets interesting. C.H. Robinson Worldwide arranged for Caribe Transport to haul this particular freight shipment. Montgomery discovers that both the driver and the motor carrier had terrible safety records.
How terrible.
Caribe Transport had a conditional safety rating from federal regulators, basically a warning that they're unsafe and under extra scrutiny.
And get this, C.H. Robinson's own internal policies required them to refuse any motor carrier with a conditional safety rating.
So they violated their own safety rules?
Exactly. Montgomery argues C.H. Robinson knew or should have known about these safety problems, but hired them anyway because they needed someone fast.
What happened in court?
Initially, the Southern District of Illinois sided with Montgomery. The judge followed a Ninth Circuit decision saying negligent hiring lawsuits against brokers fall within the federal law's safety exception.
But then?
Plot twist. The Seventh Circuit decided a different case called Ye versus Global Trans Enterprises, ruling that federal law completely preempts these negligent hiring claims. Following that precedent, Montgomery's district court reversed course and granted judgment for C.H. Robinson. The Seventh Circuit affirmed on appeal.
So now Montgomery can't sue the broker who negligently hired the driver who destroyed his leg?
That's where the circuit split comes in. The Ninth and Sixth Circuits say victims can sue. The Seventh and 11th Circuits say federal law blocks those lawsuits entirely.
The Supreme Court granted certiorari to resolve this split about trucking broker liability under federal preemption law, and it's a perfect vehicle for clarifying how safety exceptions work in federal preemption cases.
Montgomery makes three primary arguments why he should win. First, he says the federal law's safety exception explicitly preserves his tort claims from preemption. The statute says federal preemption shall not restrict the safety regulatory authority of a state with respect to motor vehicles. Montgomery argues this language preserves exactly what he's doing, using state tort law to hold companies accountable for unsafe hiring practices that put dangerous vehicles on the road.
His second argument focuses on fair interpretation. He says you cannot read the preemption provision broadly while giving the safety exception a narrow, stingy interpretation.
What does that mean practically?
Montgomery points out that the Supreme Court already said the phrase, with respect to the transportation of property, in the preemption section, massively limits federal preemption scope.
So if that language limits preemption, then, with respect to motor vehicles in the safety exception, should preserve state authority broadly?
Exactly. Montgomery argues respondents want it both ways, broad preemption but narrow exceptions.
His third argument goes to legal history. Montgomery emphasizes that negligent hiring claims against motor carriers existed long before Congress passed this federal trucking law.
He cites cases from the 1960s and 1970s, plus the original restatement of torts from 1934 establishing negligent selection as standard common law. His point being, Congress knew these longstanding tort claims existed when they wrote the safety exception, so they obviously intended to preserve them.
Now, let's flip to C.H. Robinson and Caribe Transport's arguments. They make three counter-arguments. First, they say federal law's preemption provision applies broadly to broker selection decisions. They argue that negligent hiring lawsuits necessarily regulate broker services because they affect how brokers conduct business and spend money.
Second, they claim the safety exception applies narrowly only to direct regulation of motor vehicles themselves.
What counts as direct regulation?
C.H. Robinson argues the exception covers things like traffic rules, vehicle inspection requirements, claims against drivers themselves, but not claims against brokers for hiring decisions.
They distinguish between regulating vehicles versus regulating the business relationships around vehicles.
Exactly. Their third argument emphasizes that comprehensive federal regulation already addresses motor carrier safety. They note that the Department of Transportation and Federal Motor Carrier Safety Administration already regulate carriers and brokers extensively. Plus, they argue victims can still sue the actual motor carriers and drivers who cause accidents, just not the brokers who hired them.
And then there's the federal government weighing in. The United States filed an amicus brief supporting the trucking companies, making three arguments. They'll participate at oral arguments. First, they push a direct connection test, saying the safety exception only covers state laws directly connected to motor vehicle operation or maintenance. They argue broker hiring decisions lack sufficient direct connection to motor vehicles to qualify for the safety exception.
Second, they worry about making statutory language meaningless. The government argues Montgomery's reading would make the phrase, with respect to motor vehicles, basically do nothing because it would cover almost all safety regulation anyway.
Their third argument focuses on federal oversight adequacy. They emphasize that federal agencies already regulate motor carrier safety comprehensively, including broker registration and financial responsibility requirements.
The government argues this creates appropriate balance between safety regulation and congressional deregulatory goals.
Here's what's really interesting about the government's position. They actually switched sides. We flagged this in several cases this term. In an earlier Supreme Court case involving C.H. Robinson, The government argued that negligent selection claims against brokers do fall within the safety exception.
So they completely flipped their legal position?
The brief acknowledges this, saying they reconsidered after additional intragovernmental consultation and deliberation, and further percolation of the issue in the courts of appeals.
Time for what this actually means. If the trucking companies win, what happens to highway safety?
Brokers lose a major incentive to carefully vet the carriers and drivers they hire. Think about it economically. If brokers face zero legal risk from hiring unsafe drivers, what drives them to spend extra money on safety checks?
They'll just hire whoever offers the cheapest rates, regardless of safety records. And these aren't small delivery trucks. We're talking about 80,000-pound commercial vehicles sharing highways with families.
But if Montgomery wins,
Brokers face real financial consequences for negligent hiring decisions. That creates market incentives to properly screen carriers and drivers. It also means victims of trucking accidents have someone with actual insurance and money to sue when carriers and drivers can't pay for the massive damages these crashes cause. Because here's the thing, a lot of small trucking companies carry minimal insurance and limited assets.
so even when victims win lawsuits against the actual carriers, they often cannot collect meaningful compensation. Major brokers like C.H. Robinson have deep pockets and substantial insurance. They can actually compensate victims for life-changing injuries.
Looking ahead to oral arguments, what should we watch for?
First, expect intense questioning about statutory interpretation methodology.
The justices will want to know whether, with respect to motor vehicles, should get broad or narrow interpretation. Watch for questions about the relationship between the preemption clause and the safety exception.
If the safety exception only covers direct vehicle regulation, what's left of state safety authority? Justice Roberts will probably focus on practical consequences for highway safety.
And Justice Kavanaugh often asks about regulatory gaps. If we block these state lawsuits, what ensures broker accountability?
Bottom line time. Why does this case matter for regular Americans?
Because it determines whether trucking brokers face meaningful accountability for dangerous hiring decisions that put unsafe vehicles on our highways. Every time you drive next to a commercial truck, this case affects your safety.
Congress deliberately created a safety exception because they wanted states to keep regulating highway safety even while federalizing trucking economics.
If brokers get blanket immunity from state tort lawsuits, they lose major financial incentives to prioritize safety over cheap rates.
But if victims can sue brokers for negligent hiring, that creates market pressure for better screening and safer roads.
Plus, it ensures that victims of devastating trucking crashes have someone with adequate resources to provide fair compensation.
The circuit split shows federal courts fundamentally disagree about how to balance federal deregulation against state safety authority.
This case will clarify whether safety exceptions in federal preemption statutes actually preserve meaningful state authority or just create the illusion of preserved power.
That's Montgomery versus Caribe Transport. The oral arguments should be fascinating.
We'll have a breakdown after oral arguments, plus analysis when the decision comes down.
If you made it this far, share this episode with someone who drives on highways with commercial trucks.
Which means basically everyone.
You can find us on Apple Podcasts, Spotify, YouTube. Just search The High Court Report. Questions about this case? Hit us up on LinkedIn at The High Court Report. Talk to you soon.